Hello and welcome to the 13th episode of Wahl on Law. My name is Jonas Wahl, and I am a pre-law student at the University of Delaware. On this podcast, we cover what's happening across the country in law and policy and how it affects your daily life. Today, we're joined by a special guest, Charles Sanders, who is the managing partner of Rose Sanders Law Firm, to break down the Protecting Automobile Accident Victims from Attorney Self-Dealing Act, a new proposed law making national headlines. Mr. Sanders, thank you so much for joining us today.
Jonas, thank you for having me. I appreciate it.
So, before we get into this act, can you briefly explain the type of law you practice and the kinds of cases you typically handle?
Well, I'm a personal injury lawyer or plaintiff's lawyer, and we handle mostly people that are injured by the negligence of a third party, like a car accident, a slip and fall, an injury on the job done by a third party, some just different types of catastrophic accidents. You know, I can list a plane explosions, ship accidents, boat accidents, any type of accident where there could be a negligent third party. That's the type of law we practice. We also do a little bit of defamation, and in very, very, very select situations, I'll do your family law case.
So, for people hearing about this case for the first time, or this act, what problem is it trying to solve? Who's behind it? Could you just tell us a little bit about it?
Well, the name of the act is Protecting California Accident Victims Against Self-Dealing Attorney Act. It's an act that's designed supposedly to protect people from lawyers that are engaging in self-dealing. Self-dealing is when you act on your own interests. So there's a misconception about personal injury lawyers, you know, that they're ambulance chasers, that we're all about the money and this and that. And that's what helps promulgate, you know, the stereotype. And then Uber has been one of the biggest sponsors of this bill, law, whatever it's called. And they've sponsored it. And it has now gotten to the point where it has been on the ballot for November 2026 in California.
Why would Uber care about personal injury lawyers?
Because Uber gets sued by personal injury lawyers every single time there's an accident involving an Uber, and they just want to, if they could eliminate basically a lot of personal injury lawyers in California, they basically have a license to never train their employees, never worry about regulations, traffic laws, because if this passes, I'll explain later at work when you question me on it. With this passes, it's going to be basically the end of a very important industry for society in California.
Got it, and that's a great explanation. So for a brief recap, the goal of this act is to apparently ensure that accident victims keep more of their settlement. But as you said, there may be some downfalls to this act. So where do you stand on this act and why?
So if this passes, this is going to be the end of personal injury law in California, and is going to be a license for everybody to act negligent with absolutely no consequences for their actions. What it's going to do is, what the act is doing is it's statutorily capping attorneys' fees at 25% of the entire settlement, 75% to the client. Let me give you some background about how personal injury law works so you can understand. So let's say you get into a car accident and you don't have any money and it's not your fault. It's a police report. You call me. I take the case on a contingency fee. That means you only pay me if I collect for you. And I put all my money down to pay for everything regarding your case. If I have to file a lawsuit, experts for your treatment, if you need surgery, all that comes out of my pocket. And the only time you have to pay is if I secure a settlement for you. But when I secure a settlement for you, I get my contingency fee. It's either the standard in the industry is 33% if it's done without a lawsuit, and 40% if a lawsuit is filed, plus you get your expenses back. So if there's a $100,000 case, if this act doesn't pass and there's a lawsuit filed, the lawyer would roughly get a $40,000 contingency plus his expenses, and usually they're around $3,000 or $4,000, and then the rest of that money goes to the client. But out of that client portion, he has to pay his medical bills. Remember, personal injury law, you see these big verdicts on TV and on the billboards. Personal injury law was not designed to put money in the client's pocket so they could go shopping and buy a Mercedes. It's designed to pay your medical bills back that for the medical treatment that you've received to get you recovered from your injury. So when we guarantee that 75% of the settlement is going to go to the client, how are the lawyers going to make any money? How are the doctors going to get paid on their cases? So do you understand the danger and what does it to the industry if this passes?
Yes, and so while you're saying that this act would cap attorney fees at 25%, what you're saying is they usually don't go that much above it. Usually it's around like 40% is what you would typically charge.
Absolutely. Like this self-dealing attorney thing sounds like an insurance companies do. We're not engaging in self-dealing. The industry, a lot of people are just ignorant about the industry. We are literally putting our own money. We're taking faith and taking your word that you're injured and the accident happened the way it does. Because what happens, God forbid, I had a case where the client had 5 or 6 car accidents. I represented her on the first 4 or 5 of them, policy limits every time. On the 6th time, we went to trial. Ultimately, it came out of trial that she was in all the previous accidents, and I represented her. The jury didn't like her. They thought she was a liar. We lost the trial. You know how much money I got paid on that case? 0. You know how much money I put in? About $5,000. You know how much money that I got back? 0. So, and you know how much the client owed me? 0. Because we lost. It's a contingency fee case. It happens. But you're gonna be tough to find a lawyer that's gonna even take a case if it's capped at 25% is about. And it's not always necessarily about the lawyer getting paid. It's about how are they going to procure that settlement for the client if this act is going to make it so that there's not going to be enough money to pay them back for the expenses that they put in. Sorry for ranting. It's just we just opened up our office in California about 6 months ago, and every time I'm in California meeting doctors, trying to talk about my business, trying to get referrals, all they want to do is talk about this act. They're worried. They're scared.
No worries, and it's great to be bringing light to this topic to make sure people are informed about what it's doing and the effects that it could have. I do want to get into a few of the claims that this act makes to try to understand why it's even being brought forward in the first place. So, first, this act claims that most cases settle quickly, rarely go to trial, but attorneys still take up to 1/3 or even half of the monetary fees a client would receive. So, from your experience, is that an accurate picture of the personal injury system?
It depends on the case. It's also on a case-by-case basis. If I have a case where my client's not that, it doesn't look at the beginning of the case that my client's not that liable, and I have to hire so many expert witnesses, like someone gets into a truck accident, I have to hire an accident reconstructionist and a person to go download the electronic data recorder in a truck. It's like the black box that they look for after a plane crash. And that, it's $2,000 there, and then filing the lawsuit and then hiring the experts, so I have to spend money to make that client collect the settlement. So most of the time, yeah, it is 1/3. And most cases do settle fast, and most cases don't go to trial. But that doesn't mean that the lawyer still isn't putting in money of their own money into the case, and that doesn't mean that the client. And now, okay, about the lawyers. So what about the client's medical bills and the doctors that are treating these accident victims? How are they going to get paid if this passes? So no, I don't think that's truly accurate. Maybe on a case where where liability is really contested and the lawyer has to put a lot of money down and the settlement isn't that big. Maybe then after he gets his contingency fee with his fees, it might be 50. But in my experience, usually, on a $500,000 settlement, the lawyer gets $200,000 and the fees are about 10. So that's 210,000 and the rest is the client. And these bills with the doctors are usually are paid at a reduced rate. They might charge 10,000 for the MRI, but they only make you pay $750 out of it. So the bills are lowered to put more money in the client's pocket. So no, I don't think that's accurate. I don't.
And you talked about some of the fees that medical providers will charge victims. So this act also claims that some attorneys steer clients towards expensive, out-of-network medical care to increase settlements and their own fees. Does that actually happen? Like, would you refer somebody to a more expensive medical provider to help their injuries?
Well, I'm just going to try to you have to understand the industry. Our jobs are to collect for our clients on injuries. And I, as a previous insurance adjuster, have learned that settlements a lot of times are based on the amount of medical bills. So like if there's $60,000 in medical bills for you to recover from your hurt back from your car accident, then most likely you could collect the policy limits, that 30,000 or that 50,000 because there's 60,000. So it's based on how much money was spent out of pocket to get you back to where you should have been before the accident. So, and also let me add to that. Also, this inflated billing is stupid because it's no more than the doctors inflate their bills to Blue Cross Blue Shield trying to get paid on a regular surgery. If you ever gotten a hospital bill, sometimes I've seen hospital bills up in the $100,000 range because they know when they send their bill to Blue Cross Blue Shield or Humana, they're going to get $4,000. So they better bill as much as they can because that's how the insurance company pays out. So whichever way it goes, you got to bill a little higher than you expect to get. So yeah, the billing's a little higher, but I don't send a person specifically to a specific doctor because that doctor charges more. It would be more because that doctor has experience treating a personal injury client, or I know him and I have a relationship with him and we've worked together before and I could trust my client's health in his hands.
So what you're saying is this is more of a problem for the medical providers who are upcharging these patients as opposed to the attorneys who are sending them to the medical providers.
They're upcharging they're upcharging in a personal injury case just like they upcharge in a regular insurance case because they want to get as much as possible. And they all know they're not getting what they bill.
Got it. And you touched on this earlier, the fees that personal injury lawyers will typically impose, and then clients also have these massive medical bills that can sometimes leave them with debt if their case fails. How real is the risk that clients get saddled with tons of debt that they just can't afford?
I mean, it's a small risk, but if you have the right lawyer, you've gone to like I was just telling you, it's about our relationship with the physician. The physician knows that when they take this case, that there's a chance that the case could be lost and they cannot get paid. So hopefully it's somebody that you've worked with before. Like let's say I send 20 patients to the same orthopedic surgeon and we collect on 15 of them, but 5 of them don't settle for what they were supposed to, and I have to give them a call and say, hey, I know your bill is 4,000, but you got to accept 1,000 because that's all we can pay because it's only settled for 12 grand. So doctors will know that when they lose a case, most of the time they know they're just out of money.
That was a great explanation. And I want to move away from some of the claims that this act makes to now I want to talk about the solutions that it provides and talk about if these could be viable or just not good at all. One of the biggest solutions that this act proposes is a cap on fees for attorneys, only allowing attorneys to charge 25% for their fees while clients can keep 75% of the total amount of money recovered. In my opinion, that does sound reasonable. So what is the downside to this?
Well, the downside is the numbers, it's too much. But like they haven't specified whether that 75% it means into the client's pocket or their portion of the settlement. Because by limiting a contingency fee, that's hurting victims because it's going to make it harder to find a lawyer because a lawyer still needs to make money. Everyone goes to work in the morning to try to support their family. It's no different from a personal injury lawyer than a teacher that goes to teach our kids. Everyone needs to make money. And lawyers are going to be less incentivized to take these cases when they know they're not getting paid as much. So it's going to hurt. And like you had said earlier, our fee isn't that much more, than 20. 33% if you could do it without a lawsuit in these small cases is a third. 40%, $100,000 cases, 40. That still leaves 60. Lower the bills, that puts 55,000 in their pocket. Like I said before, these settlements are not designed for the client to go shopping and buy a Mercedes and go to the mall. They're designed to pay his bills back.
Building off of what you just said, a popular argument against this act is that if attorneys can't take these higher fees, they may stop taking smaller and riskier cases. Do you think this law could actually limit access to legal representation?
Well, it's going to destroy access to legal representation because lawyers aren't going to take PI cases anymore if this passes. It's very expensive to try a case. It's very expensive to get justice for a client, especially when that client doesn't have to pay us anything up front. It would be one thing if they were paying us money up front to pay us for everything for our time, but they're not. They're expecting. It's like getting your cake and eating it too. They don't want to pay. They don't want to pay the lawyer at all at the beginning of the case. They want us to put front all our money to for their case, and then they don't want to pay us for it, and they want us to take a reduced fee. What's the motivation? If you were a personal injury lawyer, what's your motivation? Would you take a case? If I walked in your office and said that, I fell at Walmart and I broke my leg, and it's on video, but you knew the most you could collect on that was 25%. Would you take the case, knowing that you're going to have to put in at least 10 to 15,000 in legal expenses of your own money?
Exactly, and also part of it is the time spent trying to get.
So clients can't get their cake and eat it too. You can't get your cake. You can't expect us to try your case, pay for everything, and then not expect the money back at the end when we just got you $1 million or something like that. And the same thing goes with the doctors. It's not free. These doctors go to work and have families to support too. And without the doctor's personal injury, you need a doctor. Without doctors, there's no case. Clients collect no money.
So, do you think that this act gets any part of personal injury lawyers right? Or do you think that this act as a whole is just no good?
As a whole, it's just no good. It's just no good because I'm glad I'm on this. Hopefully everyone that's listening could be a little bit more educated after talking to me, but no, it's no good. No good.
And apart from this act as a whole, do you think that there needs to be any reform to personal injury lawyers and the fees that they charge?
I don't. If anything, I think the fees aren't high. I think the fees should be higher, especially the 33% figure. Like some board certified personal injury lawyers charge 40% despite whether there's a lawsuit. Some lawyers charge 45 if they actually have to try the case. If you actually have to try the case in front of a jury, that could take 2 or 3 weeks, and you have to shut basically your practice down. So, sometimes the kids. I don't really think any reforms need to be made at all.
Got it. And I know that part of the issue that this act is trying to solve is that there are, in my research, there is a few attorneys that do charge exorbitant, like very high fees. But what you're saying is that it's not most of the attorneys. Like a few bad apples shouldn't poison the whole tree.
Exactly. And if a lawyer is that good, if you know you're going to get your client $10 million, charge 45% in the end, because without him, the client's not getting any of that money. Because if you think just because the accident happened, you could have your head decapitated at Walmart, and there could be a video of it, and Walmart's still going to file an answer denying that it happened and try to do whatever they could do to pay you as little money as possible. So, what's the client going to do without the lawyers? What are we going to do? They don't want to pay us. What do you think they're going to do if the client's pro se representing themselves?
Definitely. And I know that this proposed law is in California, but if this got passed in California, do you think that this could affect other states? Like, could it set a precedent?
I mean, it could, but I know in every couple years in Texas, they try this, and it always fails. And this probably isn't the first ploy in California to try to do this. Insurance companies are big lobbyers. So this is a ploy by the insurance company, billions and billions of dollars they make. So every couple years, they try to do something like this. It usually doesn't pass, but I just have a bad feeling about this one because it's in regular voters' hands, and I just not confident in the everyday voter in the state of California knowing enough about personal injury to actually be able to judge whether or not this is good or bad.
Got it. So this has been like an ongoing fight across many states. This isn't like an isolated attack against personal injury lawyers. It's been going on for a while.
For example, I'll tell you an example. So in Texas, medical malpractice case, they've capped it at $250,000, the most that you could collect, that the client can collect in a settlement, or verdict in medical malpractice case in Texas. Now, the reason why that's problematic is it's making it very hard for people that are injured by doctors' malpractice to find lawyers. Because what is malpractice? You're saying that a doctor hurt you and violated the standard of care. the only one that could testify that to that standard of care is another physician. So you have to hire a physician to testify, no, yes, that doctor did breach the standard of care. You might have to call them live at trial. And to get a doctor to come to trial, cancel their clinic and their surgeries, it's going to be thousands of dollars. I mean, you're looking at sometimes 15 to 20,000 per expert doctor to come to trial. And you might have to get an expert anesthesiologist, an expert general doctor, an expert orthopedic surgeon, so by the time you're done prosecuting the case for the injured person, there's not going to be any money left over, for anybody because the expenses are so high. So now lots of lawyers don't take medical malpractice cases in Texas, and it's like a license to just cut the wrong body part in Texas.
Great explanation. So for my last question here, what should the average person take away from this conversation?
Well, the average person should take away is, listen, the attorneys aren't self-dealing. We're simply doing our jobs. And if this passes, then there's not going to be enough money to pay the lawyers and, more importantly, to pay the doctors. And it's going to be very difficult for an injured person to find representation and to find medical treatment. Because if you're injured and you can't work, you become broke, then you can't pay for your doctors and you can't pay your bills. So you need a personal injury lawyer that's going to have the funds to front his own money to pay for your treatment and to pay for your case. And if this passes, that's not going to happen, and you're going to be in the dark. And California is the third biggest state in the country. Really, technically second. I don't count Alaska; no one lives there. But it's going to deter lawyers from taking cases, and it's going to de-incentivize businesses from practicing safety standards in all aspects of life.
And that concludes the questions I have, Mr. Sanders. Thank you so much for coming on the podcast today. This has been a great conversation, and I hope that my listeners out there learned something from today, whether this act could have some real repercussions.
So it's going to have repercussions for citizens, for regular people. Personal injury lawyers, we're lawyers. We'll find something else. We'll practice another area of law. Employment law is really lucrative in California. It's the clients that are the ones that are in danger, because they're the ones that aren't going to be able to find representation when they're seriously or catastrophically injured, or God forbid someone dies in an accident caused by somebody's negligence.
So yeah, thank you so much for joining me about this act. If my listeners like the episode, make sure to follow or subscribe to Wahl on Law so you don't miss any future episodes. You can also sign up for our email list at wahlonlaw.com to get notified whenever a new episode drops. Thank you again for listening, and I'll see you next time on Wahl on Law.